Brilliant. Okay. So thank you very much, everybody, for joining this Lunch and Learn just before the Easter break. So thank you. Hopefully, we've had quite a lot of people that have wanting to watch on the recording afterwards because they're away sunning themselves or looking after the kids during the Easter break. So thank you again. So today we're going to be talking about right to manage in the post-Grenfell world, or resident management more broadly, where residents have taken over the management of their buildings away from, typically away from the freeholder. And the question we're asking is whether, given the changes that have happened post-Grenfell to regulation, whether it's a good idea to step up to that role or to step down from it. And I think that's the point we're like to get to today, to sort of understand what are those changes and what does that mean to resident directors of residential leasehold buildings. So without further ado, I want to introduce Jon Whittaker from RTM Northeast. So I've worked with Jon on a number of projects over a number of years now. Jon's a specialist in supporting RTM resident directors. And I think probably the best thing to do, sorry, I've got something popping up on my screen now, which I need to get rid of. Is to get Jon to introduce himself. I think would probably be the best thing.
Yeah, afternoon, Matt. Thanks for inviting me today onto this webinar. So yeah, I'm Jon Whittaker. Originally started life in this industry as an RTM director myself, almost by accident, when the building that I was a leaseholder in had various issues back in 2011. This was at the time I had a career in the emergency services. And one thing led to another through sort of remediating issues in the building that I ran with colleagues. Held a number of inquiries from other local buildings to assist them, and decided to take the leap and re-qualify as a building safety manager, which is where I find myself today. And as Matt suggested, assisting resident-run buildings navigate the Building Safety Act as best as I can, and also the complicated world of remediation of defects in buildings as well.
Excellent. Thanks very much, Jon. My technical issues have now been fixed, so apologies for disappearing while you were talking. Right, okay, so what I would like to do just quickly, I don't normally do this, but because we're talking about quite a bit of legal stuff today, and both Jon and I are not lawyers, and we're not providing anybody with legal advice, we have a disclaimer on the screen there. So we are doing our best to explain quite a lot of complicated subjects from a legal perspective, and please do not rely on this. If it jars a thought with you, then please do go out and seek your own legal advice as a result, but hopefully it might open some eyes to some of the issues that RTM directors are facing. So, resident management. There is a lot of political rhetoric at the moment around the hard-won rights for residents to take over the management of their building, and a lot of sort of swell towards that kind of activity, and rather than just having that sort of freeholder appointed managing agent relationship. But the key point to understand is that with that responsibility of the right to manage the building also comes a lot of legal liability as well for those amateur directors or resident directors. Principally post-Grenfell, we've got the Building Safety Act. So if your building is over 6 stories or over 18 meters to the floor level of the uppermost floor, then the likelihood is that will be a higher risk building under the eyes of the Building Safety Act, the law, and you will then be responsible for your Part 4 duties as the principal accountable person. So you, in most cases, the resident management company or the RTM company will be the accountable person in law, which means that you are responsible if that law is broken. That isn't something that can necessarily be outsourced to a third party. You're also subject to the fire safety order, regulatory reform fire safety order, and its subordinate regulation. So principally, and we will go through this in more detail, that is the Fire Safety England regs and the Residential Evacuation plan regs that commence on the 6th of April, which are in addition to your previous responsibilities under the fire safety order prior to the last couple of years. So there are different models and confusing all these things, but effectively when we're talking about resident management, we're talking about right to manage resident management companies, and maybe we'll talk later about what the difference is between those two. And then also enfranchisement, where the residents have jointly bought the freehold to the building or jointly own the freehold of the building. But ultimately, these are all what I would define as resident management models. And it's about understanding the legal liability that's incurred. There is also the human factors of self or resident management, which is, you know, when your neighbours aren't paying their bills, for example, having to deal with that. Effectively both being a resident within the building, but also a manager of the building or responsible for the management of the building, and all of the human stuff that goes with that, which I think is not really what we're going to get into today unless it comes up in the questions. But ultimately what we want to try and do is stick to the technical legal aspects of this. So the resident director liability. So under the range of laws that you are subject to if you are one of these directors, the fines, the financial penalties can be unlimited. There will always be a view between whether this is personal liability for the company that you are a director of, etc., etc. But ultimately, the courts have the ability to levy an unlimited fine. And then, from a personal perspective, in terms of prison sentences, the Building Safety Act is a 2-year maximum prison sentence for breaches. The reason that I put 18 years on the screen is because that, as I understand it, is the maximum tariff for gross negligence manslaughter. So if manslaughter charges were brought against the resident management company, it would probably be corporate manslaughter, which is, as I understand it, there's no prison sentence for that. But if charges are brought against the individual director or directors, then that would probably be the maximum tariff. So that's sort of the extreme end of what we're facing here if this all goes horribly wrong. And some of that liability can be outsourced. So, for example, and we'll talk about it more in detail, but under the fire safety regulations, where we have a responsible person regime, that liability can be shifted to a managing agent, for example. They could be seen as the responsible person for that building, whereas you can't escape your accountable person duties under the Building Safety Act. So again, there are lots of different regulations and laws here that sort of interact and come to pass on a residential building, all with slightly different regimes and different tariffs and different responsibilities. So what actually changed post-Grenfell? So before Grenfell, and this isn't an exhaustive list, but we had the Fire Safety Order, which I've just talked about. We had Health and Safety at Work Act, the ZIA regulations, which is about explosive atmospheres, etc., which sort of comes into communal boilers and those sorts of things. LOLA, which is around lifts, Legionella, electrical wiring, on it goes in terms of regulatory requirements to comply with as responsible entity for managing buildings. Different regulators enforce different parts of the law. Some of it's health and safety executive, some of it's the local authority, some of it's the fire service, etc., etc. So that's what we had before, which was quite an exhaustive list of things to do. Post-Grenfell, there is a layer on top, which, depending on what you're doing with the building and how tall it is, will be massively invasive or not very invasive at all. So they are the Building Safety Act, and about, I think from memory, there's about 20 sets of regulations that sit underneath the Building Safety Act itself in terms of requirements for buildings that are either passing through building control or the ones that are being occupied over 18 metres. The Fire Safety England regs, which again are graduated based on the height of the building, in terms of how much legal responsibilities or duties that you have. And again, we'll go through that in a bit more detail in a minute. And then now, as of the 6th of April, the residential personal emergency evacuation plan regulations, which again we'll go through, but that is for higher rise buildings, which is the definition I talked about before, and mid-rise, which is sort of above 4 stories and below 7 typically, that have a simultaneous evacuation strategy in place. So again, depending on how your building is designed from a fire perspective and how it has been adjudged to perform in a fire, will depend on what the evacuation strategy is. If the simultaneous evacuation strategy, which is the alarms go off, everybody gets out in the event of a fire anywhere in the building, put simply, then your building will be subject to the RPEEP regulations. So again, with each individual building, it's about understanding exactly what rules and regulations apply to your particular building, because it will change. And I can't just sort of blindly say everybody's the same, do this, because the answer always is it depends. John, from your perspective, sort of looking at this from having sort of seen people through this change, what have you noticed in terms of response to these extra responsibilities, and whether people actually understand what regimes apply to them?
I think it is complex, and I think resident-run buildings are still finding their feet on this. In fact, as are a lot of the experts and legal people in this arena. We are starting to see RTM companies start to seek expert advice, whether that's from external consultants or via their managing agent. But in a lot of cases, it's still very early days. We still have buildings that haven't started looking at safety case reports and the various other policies and procedures that have to be implemented as part of the regimes. And I think that there is, in some cases, an assumption that their managing agent should be doing this for them, when actually it's possibly a significant extension to what they're doing already. So the managing agent may need to increase their fees or bring in external experts themselves to assist resident-run buildings through this new framework. Yeah,
and I think that's an important point of understanding, firstly, what type of building you live in and you run, and how well diagnosed is that. I mean, I'm involved in, as I'm sure you are, John, a lot of cases at the moment where arguments are still ongoing as to whether a building is actually a higher risk building under the definition of the Building Safety Act, even though they were all meant to be registered by September 2023, October 2023. The arguments are still ongoing about, does this building qualify or not? And that can have a whole host of implications legally and from a project perspective. If a building that isn't an HRB becomes an HRB, or vice versa, that can cause significant issues and legal liabilities. So yeah, it's a complicated set of regulations that need to be complied with. So looking into the Building Safety Act in a bit more detail, key thing to bear in mind with the Building Safety Act is it's a risk-based rather than rules-based regulatory regime. So it's for you as the principal accountable person to demonstrate that risks are being effectively managed in your building. It's not a question of saying you've ticked 12 boxes, therefore you are compliant. You need to demonstrate that the building is safe, and there's a whole regime for managing that. But it does include a golden thread of building safety information, so that is prescriptive. You need to keep digital records about the building, building safety information. You do have a legal requirement to engage with residents in a formal, codified way. You do have to report incidents if they happen. It's called mandatory occurrence reporting. So there are a number of things that you must do, but the regulator has been very non-specific, shall we say, about how you do those things. So it's very much open to interpretation, and where you've got lots of room for interpretation, you've got big opportunities for abuse or confusion or wasted cost, which is not helpful when you have people making these decisions that are not doing this every day of the week. for a living. They have lives to live and want to live in a flat, and have probably stepped up and said, "Look, I'll be a director of the management company because, you know, I'm a great accountant, or, you know, I really care about the building I live in," or whatever. And the language in this is around accountable persons. So in the Building Safety Act, we have accountable persons and principal accountable persons. So if you have more than one accountable person within a building or a block, then one of them takes the lead, and effectively they're the principal accountable person. Where there is only one accountable person, they are by default the principal accountable person. So when we're talking in this, if we talk about PAPs, that ultimately is the accountable person that's at the top of the pyramid. They're the ones that deal with the regulator. So in terms of those considerations, I mean, as we talked about before, you know, do you live in an HRB, a higher risk building under the Building Safety Act? If you do, or you don't know, you need to find out. If you do, you need to make sure that it is registered with the regulator. Failure to register is a criminal offence. Once you've registered, you are then a part of the regime, and there are various things you have to do. You have to upload key building information about your buildings. So that's the number of fire doors, what the walls are made of, roof insulation, massive long list of information you need to provide. And you need to maintain a safety case for the building, a safety case report, mandatory occurrence reporting, resident engagement strategy. And again, we've been through a number of these points on other lunch and learns in terms of the detail, and they're all archived to on our YouTube channel. So remember that the height definition that I talked about, but again, in the presentation that we'll send out afterwards and on our YouTube channel will be links to previous webinars where we've talked about sort of parts of this regime in a lot more detail. So key one, Building Safety Act, there is a new regulator called the Building Safety Regulator, and they do have pretty draconian powers if you fall foul of them. And we'll come on to what's happening. But how much of your time, Jon, is spent in and around the Building Safety Act in terms of interacting with clients? Is that the primary discussions that you're having?
Yeah, aside from handling remediation projects, over half of our time is assisting principal accountable persons navigate this regime. And as you say, the starting point in this is often quite a significant task, because a lot of these buildings have very little information, especially if the RTM's taken over some years after it was built. Retrospectively locating information about the building to then understand what the building safety risks are and pull together a safety case report can be quite a monumental challenge. So it is very challenging across the industry at the minute, yeah.
And I think having that support, and I completely get for resident directors that, you know, not only are you having to commission this work, which can often be quite expensive, but also you're then having to go and tell your neighbours that they need to contribute to this through the service charge. And certainly from what I see is quite a lot of pushback sometimes from resident directors that are just saying, look, you know, this is over the top, this is a ridiculous amount of money, or whatever, however cheap you try and make this process, this does generate a lot of extra work for somebody than they had before.
You're quite right, yeah.
That needs to be paid for, and it needs to be done by somebody that's competent, which I think is the word I haven't mentioned yet, where I have seen cases of resident directors that say, well, we'll sling this together ourselves, which they may do a good job of putting that safety case together, but ultimately when it's submitted to the regulator, and one of the questions they ask is who prepared the report and which parts of the report did they prepare. So if you're a taxi driver and you fill out the bit about the structural condition of the building, be prepared that the regulator might come back and say, you might be great at driving a taxi, but what do you know about structural engineering, for example? So it's about having not only what you say to the regulator, but being able to demonstrate the competence of the people that have given that advice and have helped assess that risk. So again, if you are in the regime, you are in the regime. It doesn't differentiate by saying, well, you're only just in the regime, therefore we'll only sort of give you a light touch review. If you're 5 stories above a restaurant with 4 flats, but you hit that 18-meter threshold, you will be treated in the same way as somebody with a 50-story residential block in Canary Wharf. You know, the law is the same. There's no graduation under the Building Safety Act. So in terms of moving liability, there is provision and within the primary legislation of the Building Safety Act for a building safety director. And that effectively was created to allow resident management companies or resident directors to appoint a paid building safety director and pretty much sidestep their liability, because that liability is transferred to the building safety director to discharge the duties under the Building Safety Act. That's the sort of the good news. The bad news is that a consultation was launched in 2022, closed in early February 2023, and has never become law. So there's never been any secondary legislation issued or guidance which actually effectively makes this a law but not a law. And this is what the TPI, the Property Institute, they're the management body, if you like, for property managing agents and property managers, that have again advised recently, as late as December last year, that you cannot appoint and legally enforce a building safety director. So there is no legal mechanism yet for resident management company directors to outsource their liability, even though the primary Building Safety Act says you can. It's not possible to do this. The government have completely gone to ground on it in terms of being chased up for when is this going to happen? Is it going to happen? It's almost as though we've hit a brick wall. So I don't know when this is going to happen, but the provision is there. So at the moment, the liability remains with the principal accountable person. That's the key point. Have you got any thoughts on that, John? Have you heard anything around and about in terms of this discussion?
I haven't. I've seen that there are some firms starting to pop up, potentially offering this as a service. However, I've never seen it implemented, or whether it's even possible to do so, based on what you've just said, that the secondary legislation isn't yet there. So I've not seen it actioned as of yet. No.
Yeah, it's almost as though it's been forgotten about. There's quite a lot of discussion in the property press at the moment about the PTAPs did something recently about the pressures that are being put on RMC directors or resident management company directors in relation to safety cases and red tape, as I think as it's being called. But the reality is there is the legal duty to do this. There is the legal responsibility that the directors have taken on, and the government's way of managing or transferring that liability has not been enacted in law. So kind of at the moment, it is what it is. I don't know whether there's any movement from resident directors or associations that are actually pushing the government to at least say something about this. You know, I've written to them on a number of occasions, and they just say that it's under consideration. The website still says that feedback is being considered, and that's 3 and a bit years after the consultation closed. So I don't know, but if anybody does know, maybe they can put something in the comments, or if anyone's got some good ideas, because the whole idea of this is for us all to learn. The other key point I've mentioned about this requirement to register for existing buildings, that September 2023 was the end of September 2023 was the date after which you would be committing an offence to not have registered your HRB. We've recently done some testing. Some of you may have seen it on LinkedIn, but we looked in London, and we picked on a particular street that we were aware of, and sampled the entire street. And these are sort of Georgian townhouse conversions, the sort of 6-story townhouse conversions that, you know, in big long terraces in London. And what we found there was that 85% of those blocks that should be registered, bearing in mind we're now 2.5 years beyond the end date of registration, have not yet been registered with the regulator. We are seeing evidence of non-registration around the country, but it tends to be more sort of individual blocks rather than virtually whole streets. But the regulator doesn't appear to be overtly enforcing yet. They may well be doing it quietly, but that certainly hasn't come into the sort of the press's attention. But really, I don't know whether this is regulatory failure or whether it's just about regulatory priority. So I think it is a failure that that there is such a high level of non-registration. But whether they are failing as a regulator, I'm not sure. I have a view on it, but the reality is we shouldn't be seeing levels of non-registration as high as this, and it certainly isn't fair on the residents living in those buildings, and it's certainly not fair on the people that have followed the law and are incurring costs to comply with this legislation. So I don't know, John, what are your thoughts on that when you saw those numbers?
Yeah, so I mean, I was approached by a managing agent in the north of England about 2 months ago regarding one of their buildings. And they said, we think we've got a HRB here, can you come and have a look? And quite clearly, due to the number of stories it was, and it wasn't registered. So the first priority was to get it registered, get the key building information submitted and meet that compliance target. There was no kind of fallout from the regulator in that scenario. The registration was accepted and put through. And now the agent and the principal accountable person for that particular building now needs to navigate the rest of the requirements that you've already touched on, MOR strategies, engagement strategies, and safety case reports. So potentially a lot more work required for this particular building than they had envisaged previously. But like you say, there's still buildings trickling through at the minute being registered probably quite regularly.
Yeah, and we don't know yet when and if the regulator will flip, quite literally, and move into enforcement for buildings that haven't been registered. So if you are in a building where you think, and this typically there are some exceptions, but most of the ones that we're finding are the ones on that borderline where you would look at that building to the uninitiated, you would think there's no way that's a building like Grenfell. That's not a high-rise building. You know, that's ridiculous. It's just a Georgian townhouse or whatever. But the reality is, when you measure them, they fall into the scope of the Building Safety Act. So at that point, you are now breaking the law because you haven't registered, and they are very easy to find if the regulator chooses to go and look. In this particular street, obviously 15% of the buildings there are registered. So you would sort of have number 3 registered, 5, 6, 7 not registered, number 8 would be registered, for example. So it's very easy to fill in the blanks and look. So just be very careful, and if you know anybody that's wavering, strongly encourage them to get registered. I think there was a secondary conversation around, is this definition too broad? But I think at the moment the law is the law, and if you don't comply with it, you do leave yourself open to prosecution. Fire Safety England regulations, right? So these were brought in post-Grenfell to enact the Grenfell Tower inquiry recommendations, or quite a few of them, and it's all to do with checking fire and life safety equipment, checking fire doors, making sure that the external wall is included, sharing information with the Fire and Rescue Service, and these were all addressing shortcomings that were identified in the Grenfell inquiry. Because it sits under the fire safety order, the regulatory reform fire safety order, we're now into a responsible person regime rather than an accountable person regime. Again, this is a classification typically for an organization, but can also be extended onto an individual human person. And the rules, it's a rules-based regime. So if your building is of high rise, for example, then there are things that you have to do, and they are prescribed. And the number of things that you have to do increases by height of building. So this applies to multi-occupancy residential buildings of all heights, so low rise, mid rise, high rise. In low rise, literally all you have to do is share evacuation information and fire door information with residents, and you've complied with the the Fire Safety England regs, right the way through to high rise, where you have to share information with the fire service. You have to do monthly management checks of all firefighting and life safety equipment. You have to check communal area fire doors every quarter, flat entrance doors every year, and then mid-rise in the middle is sort of a combination of the two. This came in on the 23rd of January 2023, so is already over 3 years old, but is quite often overlooked or ignored set of regulations in my experience in terms of what people actually know about them. Bits of this are being done, people know about bits, but actually managing the whole suite of checks and having a fire service that understand what those requirements are and enforce them is a bit of an open area at the moment. We have on our website, and again in the notes that we'll send, we do actually have a link to a piece that we produced a number of years ago, which actually explains all the regulations and is key coded to the height of building. So again, you can look at your height of building if you know the height, and you can see which regulations apply to you if you want to comply with that. And then within our software that we provide, we actually have all of those steps mapped out and all of the content holders for you to actually hold that content in your golden thread. So again, the takeaway on this is if you want to learn more about it, there's plenty to read online, and pick up the phone and we'll have a chat about it and explain how all this works. John, what's your take on Fire Safety England regs in terms of monthly management inspections, fire door checks, etc.? Have you seen that bedded in, or are you still having to explain this?
Yeah, well, a bit of a mixed bag, but on generally, we're finding that it is picked up and enacted without much hassle. I think the guidance around this is fairly straightforward. A lot of it should have been carried out already. For example, your regular checks on your fire safety systems, the weekly fire alarm test should be happening anyway under the British Standard for Fire Alarms. This has just sort of grounded it a bit further. And a lot of the activities can potentially be outsourced by a competent maintenance firm. They can come and test the equipment in the building monthly, and so on. I think the trickiest thing I think people are finding is the flat entrance door checks on an annual basis, especially when you have a building with multiple units into sort of 3 figures and above. Getting access is tricky, and I forget the exact wording, but it's something like reasonable or best endeavours to carry out those checks, and demonstrating that is the trickiest part of this regulation. Yeah. But in terms of enacting it, it is relatively straightforward to comply with this, with a reasonable, robust maintenance regime in place.
Yeah. Yeah, and this ties with the RPEEP regulations, which we'll come on to in a minute, where reasonable endeavours or best endeavours, or however they're described, it's about actually doing these things and keeping the records and the evidence that you've done it. So if for example you haven't been able to get into a flat for a long period of time or check the door, then you've got the records of how many times you tried, how you escalated it, what you did. Ultimately there are you could go to court and get powers, but if you've shown willing and said, look, we tried, we wrote a letter, we knocked on the door, we did this, we did that, we've recorded those activities, but we just can't get this door open, then that's really, I think, complying with the regulations. I think the other conversation that popped up again today on LinkedIn was around the qualifications or the competence of people doing these checks. The Fire Safety England regs were written in such a way that the way it was described by government was that a caretaker in a building should be able to do these checks. Now, whether the caretaker considers themselves competent to do that is another question. How that caretaker is managed, but ultimately there is also an industry of people that will say we're fire door inspectors, and we need to come in every year and measure gaps and and take down serial numbers, etc. Probably my view would be that if you've never looked at those doors properly, you probably want to get somebody with a higher level of competence to do that initial survey or audit. You don't need to get them back 3 months later to look at the communal doors again and pay them a great cost. You could actually just make sure they're still on the hinges, they haven't drooped, they still work, they haven't been changed. I think it's about proportionality in this. I don't know, what do you think, John? What have you seen?
Yeah, I would agree with that. I think some of the fire door inspections need to be quite detailed and intrusive. Basic matters such as taking architraves off and checking for fire stopping around the frame, for example, that clearly needs some form of specialist input. So you need to know your starting point. Are these certified doors? Are they notional doors? Will they likely do the job in the event of a fire? That's your starting point, and that needs a competent assessor, I think, from day one. Going on from there for your regular checks, once you've got that baseline, like you say, less intrusive, less detailed checks may be able to be justified on the annual and quarterly basis. If you're satisfied that the doors will function in the event of a fire, then make sure they're maintained. But like you say, anyone looking at a fire door needs training before they do it. Suggesting that a caretaker could do it possibly needs to be taken with a pinch of salt unless they've had some training through this.
Yeah, and just for anybody that isn't involved in this day to day, and technically is when John was talking about this, so we're talking there about you can imagine a fire door with a door frame, and then around it is a nice architrave around to frame the door. Quite often what happens, especially in newer builds, is when you pull those off and take a look, the door frame is hanging around in space, and there's a big air gap around them, and they're not sealed properly, they're not tied in properly. So if there was a fire and the smoke and flame can get in through around the door, even though the door set itself might close and might perform in a fire, effectively the wall around it or the opening around it can be the point of failure. So unless you've actually taken some of those off and looked, you don't know, because all you can see is a piece of wood around the door frame, right? So it's about that kind of survey work that lets you understand what your baseline is. And again, some of these things are quite often not explained properly to resident directors around why professionals are recommending that this is the course of action that is taken. It's for a reason, ultimately, to be able to evidence any decision that's made about the fire strategy of the building. You don't want to find out that this thing's going to fail in a real fire. You want to know beforehand and act accordingly. So that's the Fire Safety England regs. PEEPs. So 6th of April 2026, which is next week. Again, this is a recommendation from the Grenfell inquiry that was rolled over by the government. I think it was probably put it into the too difficult box for many, many years. But ultimately, this is about identifying people that can't or may have problems self-evacuating from a building. And there is a process that you now have to put in place. And again, this applies to higher risk buildings. So the ones in the scope of the Building Safety Act, so the ones that are 7 stories or more and or over 18 meters, and mid-rise buildings that have a simultaneous evacuation strategy in place. What I'm finding with most clients is they've got the data around where their HRBs are, they've identified those. But when you ask them the same question with a portfolio of, well, how many mid-rise with simultaneous evac have you got, that's often a more difficult question to answer. They are the buildings that are in scope, and you need to have a process in place too, starting with identifying relevant residents. So a relevant resident is enshrined in the regulation, and that is somebody that would need or is effectively evacuation impaired, so may well need help to get themselves out of the building if there was a fire or an emergency. So your duty as the responsible person is to make best endeavours to identify these people. You don't have to find them all. You don't have to force people to enter this process. What you've got to do is say, I didn't just ignore this, I made reasonable endeavours. Once you find these people and they come forward and they say, yes, I want to engage, then there is a process of a thing called a person-centred fire risk assessment, which you as the responsible person would need to facilitate and conduct. And then an emergency evacuation statement might be agreed, which effectively is an agreement between you and the relevant resident of how they would evacuate the building. And then if they give explicit consent, a summary of that information is then shared with the local fire and rescue service. So there's layers of consent. It is actually quite a complicated process, which I'll come on to in a minute. And that information that you share with the fire and rescue service will either be or will be put in your secure information box, which is the red fire box on the wall, which in some of the buildings we're talking about, you would have had already for the Fire Safety England regs. But in mid-rise, you probably wouldn't have done, but you would now need them if you need one if you have simultaneous evacuation. So again, that's another area of expenditure and management that you would need to install in your building. So identify, share information with the fire rescue service, and then some of the fire and rescue services want that information digitally as well. And they all have different ways of ingesting that information from you as the responsible person. We have on my LinkedIn page, we have been tracking the readiness of the fire services over the last 5 or 6 weeks for this new law to ingest this information. And on there, it does actually show, as at the last check, what each fire service was looking for in terms of how they want to receive the information. And unhelpfully, they're all either doing it differently or haven't specified. So the default needs to be, at very minimum, that this information gets put into your secure information box in the building. But just be very careful about consent, very careful about data protection regulations in terms of some of the fire services, for example, are asking for the resident's name in the digital submission. That we believe is unnecessary. It's not called for in the regulations. All they need to know is the flat number and the floor and what type of assistance is required. That's all they need to know by law. And again, it's codified. This is based on reasonable endeavours. So again, what is reasonable will be decided by the regulators, but our view at the moment is that you've made people aware of this, for example, with an awareness poster in the building. You may have written them a letter in the next few days to explain to them how to come forward. You might go and knock on their door, and then you might review that regularly and sort of maybe tie this in with your flat entrance door checks, for example. So if they're opening the door for the flat entrance door check, have a chat to them about evacuation and record those interactions so that if anybody was to assert that you've been unreasonable in your endeavours, you can turn around and say, well, I'll trade you my demonstration of reasonableness. And if we need to let the court decide, we can. So it's about keeping those records. We have had a webinar specifically on RPEEPs, which is linked in the presentation that we'll share, where we go into a huge amount of detail about the regime and how to comply with it and what various things mean. What's your take on RPEEPs at the moment, John?
I think the point you raised at the end there was really accurate, actually, Matt, in terms of tie it in with other activities in the building. So where we're doing things like annual fire door checks, we don't just have the fire door surveyor there, we also have a resident liaison officer in company. And whilst the fire door assessors doing their thing, the RLO can have a discussion with the tenant around all these matters. It can also potentially be tied into the obligations to understand who's living in the building, as in the Building Safety Act, and the resident engagement requirements as well. So when you're canvassing the building to find out who's living there, as you should be doing anyway, and keeping records of who's living in the building and any impairments they have, this could be incorporated into that. And there are some examples of some good digital platforms being developed by firms to assist resident-run groups in kind of maintaining this data, all as part of the golden thread. So there are solutions out there to assist in this process.
Yeah, brilliant. Okay, which leads me on handily to a new toolkit which was just launched, which you may have seen on LinkedIn. But effectively, what we did is sort of said, well, what is the easiest, most cost-effective way for RMCs to actually comply with the RPEEPs regulations? So effectively, we've broken that down into a series of forms and guidance documents, which we can talk about afterwards. If anybody's interested, let me know and we can give you a demo. But effectively, if you fill in these forms and you follow the guidance and you store the information, then you will be complying with the RPEEP regulations. There is a whole other world outside of this around Fire Safety England regulation, compliance, Building Safety Act compliance, etc., broader golden threads. But if you just said, I just want to do RPEEPs, that's what this product does. And as John says, there are other ways of doing it. For larger organisations, there are ways of having all of this interaction digitally with residents. It just really depends on the amount of this that you've got to do, the timing, what you do with other systems. But ultimately, however you do it, even if you do it in an Excel spreadsheet, the key thing is that you're keeping those records so you can evidence the work that you've done. So again, please do let me know, send me a message, put something in the comments or whatever, if you'd like a sort of a one-to-one chat about how this works, and we can show you how all the forms work. But there are 9 assets plus a guidance document, right down to the level of posters for notice boards, calling cards if you knock on people's doors, a letter to residents, all templated, which I think hopefully people will find useful. Certainly existing clients have found very useful, and you know, it's available for everybody else if you're interested. Remediation. So this falls sort of outside of the general sort of legal compliance, but is really, really important because there are thousands of buildings, mid-rise, high-rise, low-rise, etc., still that are either starting remediation, going through remediation, or don't know that they need remediation yet because they haven't been assessed. And I was hoping to get you into talk on this, John, because this is a huge amount of your work, isn't it, in terms of the role of resident directors in this whole process and where it goes right and where it goes wrong. I think would be really good to get just your feedback on this whole point.
Yeah, so one of the sort of implications of the Building Safety Act duties and assessing building safety risks is that 90% of the time you find something wrong with the building, whether that's a managerial or maintenance issue, but more common is a kind of base build defect that would come into the definition of relevant defects under the Building Safety Act. And then there's a duty upon the resident management company to put those right, or at least manage them in the interim as well. There's a number of funding schemes available, which are, I think, getting better as time goes on. Certainly the cladding safety scheme has come on leaps and bounds since its early inception as the Building Safety Fund back in 2020. That almost provides a guarantee that if your building is 11 metres plus and has unsafe external wall systems, funding is available there to reduce the risk to tolerable level based on an assessment. I believe a new scheme was launched yesterday as well to assist buildings requiring interim measures. So where we need to change the evacuation strategy to say, in the event of a fire, everyone leaves the building. Funding is available to install fire alarms as well. There are still gaps, and I'm sure we'll come on to talk about that shortly. But yeah, help is available out there, and there are people to sort of guide the RTMs and RMCs through this process. We've also got the developer pledge, which a select number of developers have signed up for, and they're coming through to fix issues with buildings built in the last sort of 30 years or so. And some of the developers are doing an enormous amount of work around that as well.
Yeah, I mean, I think my observation of it is it can be a real minefield in terms of the different funding pots, what you can pay for, what you can't, etc. And understanding how to navigate those. And the fact that, but the other thing that I think a lot of people aren't aware of is that professional advice to resident directors can, in most of the funding schemes, can be paid for out of the funding pot, even if it's the developer contract. Yeah. You can get representation. You don't have to do this on your own. So really, the sort of the call to action there is to make sure that you get professional help. And just dropped on the bottom right of the screen there was the news story that broke a couple of days ago about the Spectrum building in Dagenham that was probably halfway, 3/4 of the way through its remediation when it burnt to the ground. And the government seeking, the reporting is about the government seeking the money back from the now insolvent or in administration freeholder, and therefore the liability for that cost that may come from the leaseholders in the building, the residents, and it gets really complicated in terms of insolvency law from what I've read about it, but it's not clear. So not to say that's going to happen, but there are pitfalls legally as well of contracts that are signed. And what I would always say is just make sure you are advised properly by people with experience. It's not something that I do. I would go to somebody like Jon and say, Jon, look, this is one for you, nothing to do with me, but this organization needs your help, to make sure that a proper project team is built around your remediation project and your funding application. So I think, circling back to it in terms of minding the gap, so we've got the sort of the need for technical knowledge because we've just scratched the surface of the legal requirements. We've got the understanding of multi-occupancy living that was missed by the regulator at the start, in terms of the fact that although a building might not be particularly complicated, the relationships that are formed between the parties involved in living in and running multi-occupancy buildings can be complex, and can be challenging. And then we've got the regulation that sort of spans those two things. And I think because they are quite far apart, it does need people to actually help you navigate and ultimately get you to the point of regulator readiness. The fact that, ultimately what you do not want is to get caught and be the organization that gets dragged through the courts and fined. How do you go about making sure you've got that level of readiness up? So I'd say Jon, myself, lots of other people can help with that, but we need to be invited in to advise. I think for me, that would be the plea to residents. What do you think, Jon? What are your thoughts about the awareness of help being available?
Yeah, I think we touched on this earlier when we had a chat before the webinar, that a lot of the training courses and advice is provided through professional bodies such as TPI or the IFE, and it's generally the managing agents or people like myself that are part of those professional bodies that get that advice. There's still limited training and information out there targeted potentially for free to resident buildings run by RTM and RMC directors.
Yeah.
And I think what you're doing here is filling that gap and ensuring that the message gets through. But possibly more needs to be done at government level to make sure that those that are kind of lay people in this and needing assistance know where to turn and who to ask for assistance.
I do definitely feel that resident directors have been sort of left swinging in all of this without proper support, which is reprehensible. So ultimately, given these risks, is it worth it? Would you do it? I think that's something I think everybody needs to reflect on, and I applaud people that come forward to be on these boards. It needs to be done. My personal view is that more needs to be done to protect innocent people that have stepped into these roles. That it's not the professional role to do this. We really shouldn't be dumping huge amounts of liability onto people that are not trained to perform these duties. Is my personal thought. Maybe we'll come on to that as to more of a sort of a pose of a question. Okay, so over to questions. I'm hoping we've got some. Richard, have you been keeping an eye on the chat, and can you lead us off with any questions or observations that have come in? And I know we've had some in via email beforehand as well, so you're on mute. Richard, you're on mute.
Sorry, Melissa, just reading your question in the chat. It's probably easier for you to go ahead and ask that question directly of Matt, if you'd like to unmute yourself.
Yeah, thanks. I actually have to run.
Oh, no.
So I don't actually even have time to listen to the answer, but it's specifically around how leaseholders can safeguard the remediation projects to make sure that they are getting the work done that will future-proof the building, as opposed to just doing the bare minimum and then having to pay for the costs after, you know, a few years later or further down the track. But I've also sent you a message, John, so that we can catch up directly. But thanks. That was a great session.
Thank you, Norris. John, do you want to have a go at answering that one?
Yeah, it's a good question, and one that comes up regularly, and it's possibly a very complex legal question that's been tested through the courts as well. It's the difference between the obligation to reduce to a tolerable level when you're remediating a building against removing all relevant defects, and as Melissa said, future-proofing the building. I believe those definitions are still being tested through things like the first tier tribunal, and it's a bit of a mixed bag. You've got some schemes that are reducing the risk to tolerable level, and that's it. You've got other schemes that are literally rebuilding the site from scratch under new regulations, and it's quite a complex question, that one. But I believe that the baseline for remediation is reducing the risk to tolerable level, and certainly when it comes to the public schemes like the cladding safety scheme, that is what they expect. It doesn't necessarily bring the building up to current standards. But in terms of the developer remediation contract, as Melissa has alluded to in the question, in that contract, the responsible entity, if they are an RTM and RMC, they do have the right to appoint their own consultants or experts to monitor the project and provide advice, paid for by the developer if they wish to do that. And that can provide some critical oversight of what the developer's doing in terms of remediating the building, making sure nothing's missed, making sure that the scope of works is adequate, and so on.
Brilliant, thank you. We got another question. I think we've got time for one or two more. So
yes, there was another one came in earlier. What's the best way to address apathy about fire safety from other residents?
Well, I would say communication and awareness, and ultimately, although the Building Safety Act and the Fire Safety Regs have a lot of good information there about including residents and informing them, etc., you can't force people to listen to it or get interested. And I think there is an element of that's overlooked, that I think a lot of people just want to live in a flat and get on with their lives. They don't want to be worrying about fire safety all the time. There's just a sort of an assumption that the building they live in is not going to be dangerous. So it's just, to me, it's just about communication and demonstrating that you have, but you're never going to engage everybody fully, but you've got to show that you're doing your best, I think would be a sort of a quick way to answer that. But not scare people so they can't sleep at night.
We're bang on 2 o'clock here. Did you want to take one more question, or did you want
a quick one?
Yeah, so Joan McCoy has a question in the channel here. Joan, did you want to unmute yourself and go ahead and ask that question?
Hi, I was just asking a little bit more about the complexities of mixed-use buildings, because you can have such a range where you could have a small commercial unit under an apartment building, or you could have 2 or 3 penthouses in a hotel building, and what tends to happen in those cases regarding accountable persons?
Do you want to take that, John, or shall I take that?
I'll let you go ahead, Matt. Yeah. So,
assuming this is a higher risk building, so it meets the height threshold, then to answer that, the process would need to be understanding the different accountable persons and ultimately who is the principal. That's a legal process which I can't explain in 30 seconds, and I think very few people would be able to explain. But once you've established that, the duties are very clear in terms of cooperation between accountable persons and the principal accountable person, and ultimately who's responsible for submitting the key building information to the regulator and safety case reports, building assessment certificate process, etc., which would be the PAP. But it does get very complex, and can be very overly complex, especially in a building like you described, where it might be a restaurant, for example, with a few floors above it, and relatively few residents. It could be actually quite a complicated set of duty holders for what is actually a very small, probably low risk building.
Yeah, so you would be advising clients or owners that they need to have legal teams look at the lease documents to find out where the ownership lies in order to identify the
Yes.
the PAP. Yeah, okay.
Yeah, absolutely, 100%. I think at that point, I think we'll draw stumps because we are a couple of minutes over. So thank you very much, everybody, for coming along. Have a lovely Easter. Thank you, Jon, for being our expert guest. And we will all be back on the first Thursday of May, which is 7th, where I've got a very interesting guest who's a member of Parliament, who's also a housing spokesperson. And the idea there is to submit lots of questions to a real life MP that's responsible for policy to put him on the spot really about the building safety in general, housing policy, all those sorts of things. So I'll get that out to everybody, but please do start submitting your questions. And I look forward to seeing you all on the 7th of May. Thank you very much.